Mr. Chairman, sir, ladies and gentlemen, actually it is pretty unsafe to speak about privacy in the presence of so many transparency commissioners, because it may seem like you are trying to privilege an exception over what is an avowed objective of bringing in openness in all manner of working, including opening up the space which was allotted to the individual. Privacy needs to be defended because it is under threat. And it is under threat because the institutional arrangements currently which are in place, including the judiciary, has not been sufficiently cognizant about the importance of privacy to human life. The collective is so dominant that privacy today covers in fear. When we talk about privacy, we have in our mind something which is essentially belonging to that person, which he wants to hold to himself without sharing with the rest. The word privacy itself has its origin etymologically in the word privatus in Latin, which means exclusive, not belonging to the rest, which is withheld from the rest. The coming of the RTI Act is, according to me, the latest attack on privacy. I believe that privacy is under threat from everywhere, from WikiLeaks of the world, from technologies, from escalating technology, and in fact, this whole concept of debate about privacy began with the article which Justice Shah mentioned in Harvard Law Review in 1890, written by Warren and Brandeis, in which they used the famous word "to be let alone." That article had its origin in the emergence of the printing press. So technology has been a common and the most persistent threat to privacy everywhere. It is surprising that when the Western civilization itself originated in the right of the individual, which is an aspect of his privacy, today even those countries which are parts of the Western civilization are bringing privacy under threat. In most of the countries, privacy is recognized only as a semi-right. It is a Cinderella right, cowering in fear before its most established compatriots, the other rights, waiting for the fairy godmother to somehow bring the Prince Charming, which is the courts of the world. But Prince Charmings are equally hesitant. So I would like to dwell briefly on the definition and the sociological aspects of privacy in order to underline the fact how important it is to us. They say that the best portrayal of privacy is the Renaissance portrayal of Adam and Eve with the fig leaf. It shows that individuals have something to hide even from their gods. But in a world where the public interest, an amorphous idea which has very insufficient basis for its standing up, has been used repeatedly to attack privacy, which is very vital for an individual and human being. After the coming of the RTI, what one noticed was that on one pretext or the other, the citadels which belong to the privacy started falling one by one, and you don't know where it will stop. I tried to look at the other information laws of the world, the principal laws of the United States, England, Australia, Canada, and was surprised to find that they use the term privacy only as an exception. There is no mention of the right to privacy. Supreme Court of the United States in one of its judgments said that it is a penumbra right which emerges from the exercise of other rights. Now, if you are not prepared to acknowledge that privacy is a right in itself, to launch a defense of privacy in the face of this overarching, very vital attack on privacy becomes all the more difficult. The coming of the RTI Act has made the private space very difficult to defend. And that is because each time there is an arbitrational intervention in deciding what is privacy, it is quite possible that in an urge to appear like the transparency commissioner that most people are, privacy is given a short shrift. It is not happening just in India. It has happened in Australia, it has happened in the United States, it has happened in England. More so in England, because in England, privacy right is not there in the unwritten constitution anywhere. It is supposed to be the part of the tort claims, and mostly it is defended through the defense of personality, reputation, and things like that. Each time there is a litigation about protecting privacy. That essentially means that the realm of protection of privacy is the individual's realm, not the institutional realm. But if privacy is given the recognition and the standing of a right, then the institutional supports it. But privacy, as the United States Supreme Court called it penumbra, then it is left to the individual to go on supporting it. And how many individuals can support their privacy? So the net effect of all this transparency legislation worldwide has been that privacy, your privacy and my privacy, is under threat. We don't recognize it because very often when we become transparency commissioners, we dwell in an ethereal world. We virtually become an automated agency, an arm of law. We cease to be common individuals with common interests, with commonality as the fundamental to our personality. And to defend that commonality, privacy is important. I'd like to urge that we have talked about the Universal Declaration of Human Rights, which talks about privacy. But at the same time, when it comes to the other national legislations and even supranational legislations, like the European Union, you find privacy again receives the same short shifts it receives in national constitutions. It is not recognized as a right. Countries are advised to be cognizant of the importance of privacy, but that's about all. So at the end, you find a worldwide phenomenon in which privacy is not receiving the importance it is due. My fear is that we are approaching privacy with a very closed mindset. And that mindset is likely to lead to unknown consequences. My fear is that this constant, unremitting, unending attack on privacy from known, unknown sources, obtrusively and unobtrusively, creating conditions historically which can affect fundamental liberal democratic institutions. Now that fear somehow is not dominating in our thought. And unless that happens, I'm afraid we will jeopardize privacy and with that perhaps jeopardize other freedoms. The United States, as I said, privacy is not guaranteed per se, but by the Constitution. The Supreme Court has a rule in several cases that these guarantees were penumbra, as I said. At the same time, the right to freedom of speech granted in the First Amendment has limited the effects of the lawsuit for breach of privacy. So effectively, the courts are recognizing the dominance of the collective over the private. Canada has multiple federally governed acts such as the Canadian Charter of Rights and Freedoms, the Privacy Act, in which the right to privacy is protected both against encroachment by the state agencies as well as data collecting agencies. This is the only country where perhaps privacy is recognized and defended strongly. Australia has a Privacy Act of 1988, though it also has a Freedom of Information Act. and Australia is hard pressed now to bring about the common interface between the two, and they're failing. Privacy has not received the full-blooded support of the judiciary in most democratic countries, which is surprising considering the fact that the birth of the modern state had coincided with the birth of individual freedom. It is impossible to enjoy these freedoms without being assigned a unique space in which the individual is all by himself. Public interest overrides the common. It is paradox that threat to privacy should emerge from the freedom of information or the right to information laws. It is true that as both freedom of information and right to privacy address diametrically opposite principles, a certain tension between them is inevitable. The Economist warned that uncontrolled transparency, in an editorial it said, transparency is amorphous. It can, frustratingly, if anything but transparent, and implemented wrongly, may harm the very interest it is supposed to serve. The right to information law is about disclosure of information, whereas privacy is about secrecy of the private domain. The battle is between transparency and secrecy, and transparency wins because you are the mediators. This is where we need to be on our guard. Experience has shown that while promoting the mandated objectives of right to information, privacy receives a short shrift. The interpreters of law are information commissioners and would much rather veer toward the disclosing of information than allow its protection on grounds of privacy. Guardian wrote once, "It is difficult to get a man to understand something when his salary depends upon not understanding it." I believe the Transparency Commission's salary depends upon not understanding privacy. At the level of public authorities, again private information in the hands of the authority comes last in the priority of protecting information. I have noticed that CPIOs who would otherwise be very reluctant to disclose even ordinary information relating to the authority would cheerfully give away most sensitive information in their hands of private individuals. The mindset is that private information is disclosed will not hurt the public authority, and if it takes a toll on the private individual, it is his botheration. Public interest is the convenient tool to override privacy-related injunction. Very often, while invoking public interest to disclose or otherwise private information, what actually was the public interest which was being protected is left unexplained. Rarely one comes across in orders which describe how the interest so protected was so compellingly public that the private must yield to it. Further, the RTI Act does not specify the methodology that should be adopted to arrive at a satisfaction that public interest warranted disclosure of admittedly private information. Section 8J, about which Sri Venkatesh mentioned. Please read the section. It looks like an apology to the transparency commissioners. Every time it uses the word public, personal information and private information, it hems it that with public interest. The public interest override looks upon them like a big brother, both these personal information and private information. Now, surprisingly, it is the Indian Act alone which uses both these words, personal information and private information. Other acts, like United States Act, uses the word personal privacy. Australia uses the word personal privacy. Some use the word privacy alone, but personal information and privacy are both used in the Indian Act. And now that, according to me, has got a design behind it. The personal information is that information which originates in the individual but happens to rest in the hands of the state or the instrumentalities of the public. Because in the process of remaining as part of a citizen, as part of the state as citizen, vast amount of personal information almost seamlessly transfer themselves into the hands of the state. You don't know where it rests, You don't know who is controlling them. You don't know where, in what circumstances it shall be disclosed, and you shall be the loser. Wittgenstein, the Austrian philosopher, once said, repairing the damage to privacy is like repairing the damage to a cobweb with bare hands. It is impossible to repair the damage once it is done. And hence it is important that privacy must receive the consideration at the hands of the transparency commissioners. Other provisions in the RTI Act, which according to me provide protection to privacy, are Section 11 and Section 2F. Section 11 makes it mandatory that you must consult with third parties, who in most cases are private individuals, whose information you have. The tragedy is that the third-party consultation methodology under the RTI Act is a very weak methodology. It is a very weak system. You just do a pro forma consultation with the third party, and then merrily go on disclosing this information. Very often, when that party is not available to respond, or it doesn't receive your notice, or is too late in responding, and you go ahead and disclose the information. Now, Section 11 needs to be more rigorously used. I would urge the transparency commissioners to even think in terms of allowing certain time, even beyond what is mandated by the Act, so that these consultation processes are not impaired and privacy doesn't fall by the wayside. Second is Section 2F, where it is any public authority who can access information held in the private hand can summon that information, or if it holds it, can disclose that information. Very often in the financial world, like CIC and others, they collect very sensitive data about private people, their finances, their stock behavior, and all manner of things. Now this data, if disclosed, can destroy that person. Now, economists once wrote an article about what it called the asymmetry of information. According to that article, there was an asymmetry in the information in the hands of the state and information in the hands of the individual. But what it more pointedly showed was that information released indiscriminately into the market shall be destructive of small interest, while bigger interest will use the same information to flesh themselves up. So this indiscriminate releasing of information also can be destructive of individual freedom, including privacy, and most particularly privacy. Now, I would dwell upon it because it is a topic in itself at some other time. But the fact is that this explosion of information which is happening, it is leaving that little shadow under which the individual found shelter very difficult to maintain. And that needs your consideration. It is yet unclear how a provision under another law exempting privacy-related information from disclosure would be treated under the RTI. As Shri Venkatesh was pointing out, there were so many laws in the country and elsewhere where privacy is either protected or allowed to be disclosed or allowed to be invaded. Now, United States Supreme Court has called all these laws potential privacy invaders. This they are. Now, it is very important that all of you become cognizant of these laws, know their nuances, know the circumstances and methodologies under which they disclose private information. And that idea will allow you to use this public interest override for disclosing privacy-related information more discriminatingly. Australian Freedom of Information Act exempts personal privacy under what it describes as conditional exemptions. So much for its respect for privacy. Conditional exemption means that exemption shall not be automatic or straightforward. Like for security, it is straightforward exemption. Conditional exemption is when that matter arises, you discuss it with the stakeholders and then come to a considered opinion about whether information is disclosable. United States Freedom of Information Act exempts personal, medical, or similar files, the revelation of which would constitute a clear and unwarranted invasion of personal privacy. We have used this expression more or less in our act, but it hastens to again apply the public interest override without clearly saying what that override is. In another section, it exempts information which, if disclosed, would endanger the life or safety of a person. It exempts information excluded under other statutes, which our law doesn't. United Kingdom, personal information exempted under the Data Protection Act is excluded from the purview of the Freedom of Information Law. Health and sector-related information, not disclosable. Personal information relating to third party, like our act, is disclosable only after consulting the third party. Commercial interests are also not disclosable. The net upshot of all the happenings in the past, the evolution of the RTI Act vis-a-vis the other acts, including the judicial intervention, has been that privacy is a lost right. Thank you.
Before I take questions, I request Professor Madhav Menon. He wants to make an intervention. I would request him to hardly now 15 minutes left. So I request him to be.
Well, having heard the well-articulated, analyzed presentations from Justice Shah and Mr. Venkatesh on the legal aspects of this conflict between privacy and information, I believe, and now having heard Mr. Tiwari, I would like in my couple of minutes to play the role of the Transparency Commissioner. There is no dispute about privacy being a right. But the question is it only a legal right, a statutory right, or a fundamental right? Please, those people in the audience who are not legal experts and who do not know the difference between the two need to appreciate that no society will deny that privacy is a right recognized ever since civilization has started. And legal systems recognize it by the law of torts, the common law of torts recognizes it, the law of crimes recognizes it, the family law recognizes it, the tax law recognizes it, every other law recognizes the right to privacy. The question is whether the Constitution recognizes it as fundamental right, elevated it, and prevent the state from interfering with that right. So when you look at it from that angle, you will have doubts as to whether right to privacy deserves to be recognized or elevated as a fundamental right. From what we heard from Venkatesh, the Constituent Assembly had deliberated on it and in their wisdom had recognized no, it doesn't deserve to be recognized as a fundamental right. Not even perhaps if there can be a prioritization of rights, it could have found a place in the directive principles of state policy, where they have put right to work, right to health, right to housing, right to food. They're all left to the directive principles of and not as fundamental rights. Please compare for a moment, are these rights of health, food, work, etc., are they inferior to right to privacy? That right to privacy need to be recognized there, but food, health, etc. can wait for the resource of the state to be legislated as rights. So please, when you appreciate it, despite what we heard from Mr. Tiwari, we need to have a balance. And I was surprised when I heard from Venkatesh that as many as 35% of the rejected petitions fall in the category of 81A, 81J. Therefore, what I want to submit is that nobody, the balancing is not between privacy and information. The balancing has to be between liberty and security. If you recognize that privacy is part of liberty, whether you locate it in Article 21 or 14 or anywhere, and try to read into it what the constitution makers denied to include, well, it's good. We had Supreme Court has said right to food is a fundamental right to health is a fundamental right, but these are all recognized by the judicial interpretation, but not has been elevated. Even right to education was not a fundamental right. It was only recently that it was made a fundamental right. Therefore, what we are talking about privacy will have to be looked in this context, and no country, as I heard from Mr. Tiwari, the privacy was given that much of attention which the Transparency Commissioner seems to be giving. I would argue that the state has a right to have the information. If security question in the context of terrorism and all that we are having today, it is a question as how much of information the state needs to provide you the security. Where alone you can enjoy liberty. So the balancing between the two, if you were to discuss in the abstract, not in the context of the Right to Information Act, you would find that the right to privacy definitely, and once again I would like to raise that issue, when it is said by Justice Shah that vis-a-vis the public servants, the right to privacy has a lesser standing as compared to other people. How can a fundamental right to have gradations? That's a question which need to be looked into. The technology, as it was mentioned, when the printing press was discovered, as Mr. Tiwari said, you have lost part of your privacy. When internet and other things have come in, you have lost some other part of privacy. Technology is making this right to privacy or even personal information. After all, you disclose all information to your doctor. Though there is a privilege, it's a privileged communication. You have to disclose. The state will have to collect in order to protect you, your other rights. So therefore, the right to privacy and balancing of it, I would imagine that at any time, given the present state of the law, the right to information must have the upper hand. Thank you.
Just a brief comment. I'm not impressed by this percentage business. When you say 22% or 25% were rejected on the ground of privacy, has there been any examination of the cases decided by the commissioners? Have you examined that have you please see whether this has been when the information seeker has asked for information and there was a public interest, but still, I mean, it has been denied on the ground of privacy. Please don't go this and the way in which, I mean, I'm not going to, both extremes are not good. I mean, I'm not prepared to accept that the privacy is something, I mean, very trivial. It was not there in the Constitution. How many, I can give you a number of rights which are recognized by the Supreme Court, though they were not acknowledged as fundamental right, not incorporated in Part 3. For example, right to education is in a directive principle till the right to the RTI came and the Article 21A was introduced. There was no due process until the Maneka Gandhi. These are the dynamic developments by the Supreme Court which we should acknowledge. And to say that the privacy is something very trivial, is rejected, that's really awful. I mean, I would strongly, and I also cannot agree with to go to the extreme that privacy should always trump the right of the information seeker. You have to do a balancing act, and it's very difficult to do that, and it has to be done on case-wise basis.
there is no ready-made formula. I mean, but please remember that the privacy is something which all of us, I mean, consider very dear to our heart. Mr. Menon gave an example of the medical information. So, I mean, say for instance, I mean, someone in my family is unfortunately suffering from HIV/AIDS. So, naturally, I have to give this information to the doctor. Do you mean that this information can be made public? I mean, this is something extraordinary. So, this privacy is a very important right, and it should not be overridden by simply saying that the right to information would trump the right to privacy. And one thing we should not forget, that even right to information is not in the Constitution. Right to information is again is a violation by the judicial interpretation. It was not there. I mean, if you will be surprised to know that the right of the freedom of press is also not recognized in the Constitution expressly. But this has been interpreted and properly evolved. So my view is that please take the case and find out whether the information seeker is simply seeking information which would affect somebody's personal rights, or it is really there is a public interest involved. Suppose the allegation is, why say the public servant? Why I would like to make a distinction. It's done judicially. It's not this judgment of Justice Ravindra Bhatt making a distinction between the public servant and the private individual, which we confirmed now in the Subhash Chandra Agarwal's case, which is now pending in the Supreme Court. See, why this distinction is important? Because a public servant is ordinarily discharging the public function. So for example, I mean, it's so common, the allegation of corruption, the stashing money somewhere. I mean, in such circumstances, when there is suppose bank details are asked and the allegation is that this particular public official is corrupt and therefore his bank details will throw light on this. Surely this is important, because then the distinction has to be made. But otherwise, a private individual, what is his personal information? You have to make a distinction. According to me, this is a very important distinction which has to be. I'm not saying that there is a right is different. Right of we never said that the right of a public official is somewhat lesser than the fundamental right of a private individual. When we use the mechanism of Section 1381J, then at that time, this is one of the factors we kept in mind. It is not that that public servant has any lesser right. But anyway, we may take one or two questions, please. Please.
Thank you, Justice Shah. My question again is the tension between the private rights and or I would say the public right. Is it because, it's a question for you to answer, is it because that as civilization has grown, as we have evolved from the individual to the city-state to the community to the country, and where as just Professor Menon was saying, where the right to health, right to education, or right to work becomes more important, because that is of more a public good for the society rather than for an individual. Is it because of that the tension between the private rights and the right to privacy and the right of the public good is there? I just want to...
No, in that sense, if you see the constitutions of almost all countries, the certain rights like the right to education or that would be definitely given a preference.
No, the preference is because it is more valuable for the society or to the country. Ultimately, because there are externalities involved.
According to me, it's a matter of perception. According to me, the privacy is equally valuable to an individual for his individual growth, for his own.
No, I agree. It is for the individual's growth, but that growth, they see if an individual grows, everyone, they say sabka vikas, sabka hai, hoga. It is for the common good and for the common. For the country as a whole or the nation as a whole, rather than for any pursuit for his individual happiness. So that's what I'm trying to see. Where is the tension?
You see, it was never regarded, even if you read Bobin's case and the subsequent cases, it was never regarded as an absolute right. It's very, the Supreme Court made it very clear that it is recognized as a constitutional right, but it is not absolute right. I mean, even the right to information is also not an absolute right. So this is a very typical with the Indian Supreme Court, where the fundamental rights are read in on the basis of Article 21. Right to life and liberty is expanded in such a way that it now covers health, education, right to livelihood, right to shelter, everything is virtually covered. It has become a sort of an umbrella provision where all the rights are read into that. But this is the situation today. But I mean, there is going to be a conflict between several types of rights. And particularly in the context of the RTI, you have to draw a balance. I'm sorry.
Namaskar, sir. Regarding the percentage, this is for information of the distinguished panel and the House. We are weak on statistics. So just before our annual convention, conscious of this particular shortcoming, I wrote to all the states with a series of questions, pendency and this one also, how many did you reject under 81A, B, C, D, so on. So I received responses. Now at the same time, the civil society has a lot of data in the way in which the environment world and the forest world, where I used to work earlier, they are very rich in data. And those particular establishments rely a lot on the data from the civil society, and in the RTI somehow it is only the civil society which has that kind of data. So we read their literature. But after reading that literature, at least let me speak for myself, I felt that look, the actual world as it is operating seems to be at a dichotomy, quite different from what the data in the civil society literature is being revealed. But this is completely subjective. So that is the reason why I wrote to the states. So of the 28 states to which we sent a response, some 18 did respond. So some data they provided. But insofar as the breakup of 81A, B, C, D, they didn't have. They simply said that not available. So I thought let me mention this. And probably, and I say this, what I'm going to say now is that for reflection later, we'll have time to reflect. And probably one of our conclusions at the end of the session, at the end of the annual convention, should be that look, we do need to buttress our thinking and do it on the basis of data, something concrete rather than on impressionism. I think that's very important. So we have some deep dive.
This is a very important point. Venkatesh has been doing this for a long time, and he has been collecting data. It's not possible for a single organization or a single person to collect all this data. I mean, I read an article, very interesting article by your former Chief Information Commission. What is the future of the RTI? It's 10 years. It has got the imagination of the nation, but it is waning. That popularity of this is what the author has said, that the percentage of inquiries reduced. Even the rejection shows that rejection is less. So overall, the impression is that the people are not as enthusiastic as they were when the act was introduced. Now, I personally feel that it is in the hands of the transparency commissions to revive this act. And one of the ways to do it is to maintain complete data about the decisions given by them. What about the backlog, the pendency? I was told that it is in thousands. So what is going to happen to all these cases? Today, the information seeker appeal is not decided in 6 months, 1 year. It's not I'm not blaming anybody personally. These are the problems with the judiciary as well. But still, I think it lies in the really with the information commissions where they can collect the data. And please, I mean, they should ensure that Section 4 is complied with. Expand the scope of Section 4 and ensure its compliance. That by itself will reduce the litigation under the RTI, and it will really, give a further impetus to RTI. If there is no other intervention, I think it's almost patient. Yes, there is a. Will you be able to speak from there?
There is no mic. No mic for civil society.
Thank you, Justice Shah. Just to say that we completely agree that there is this tension between privacy and the right to information, and we believe that it needs to be balanced in the interest of people who are really using the Right to Information Act. And it is important that on a case-by-case basis, like you mentioned, some of these issues are resolved. We've been doing an analysis of about 2,000 orders from across different states of the information commissions. And one thing that I wanted to mention, seeming violation of the Right to Information Act is that a lot of the cases, the information commissions uphold the order of the PIO, where they say that under section 11, which is the third party clause, information is denied simply because the third party gave a veto, said that information cannot be provided. Now, under the Right to Information Act, the third party does not have any such power. They are just supposed to give their submission. The public information officer is supposed to understand whether it is truly private information, whether it would harm the interest of the third party, and only if they are convinced under the exemptions of the law, which are listed out in section 8 and 9, can this information be denied.
Thank you very much for that, raising this issue. Please, I must tell you that the third party is only supposed to give his say, to say whether he has any objection to the release of information. He has no right to veto. There is no such right. It is ultimately the commission has to decide. A third party may say that this right is this is a personal, private information, and therefore it should not be released. And then he may say that there is no public interest. But ultimately the decision has to be taken after balancing the and please, as the privacy is not to be sidelined. The public interest is equally to be kept in mind, and then after the balancing is done, the Transparency Commission will decide whether to release or not to release information. Anyway, thank you very much. I thank all the speakers.
Thank you so much, sir. We thank all our panelists for providing us with the clarity of thought and foresight for the future with regard to privacy in the times of RTI. Thank you so much. And ladies and gentlemen, with that we come to the end of our fourth session. We request all of you to join us for tea to be served right outside, and join us back within 15 minutes so that we may start with our next and last session on time. And it will be very, very interesting, the last session, as the topic is making RTI work better, experience from the states. We're just going to take a look at the ground level. Thank you and see you soon.